All right, Mark, thank you so much for joining us.
Glad to be here, Roman.
Can you please introduce yourself and your organization?
Sure. Mark Chenoweth, president of the New Civil Liberties Alliance. We sue the administrative state to defend people's civil liberties from overreaching government.
So this past year you had, I would say, not even a relatively big victory, it's a huge victory. Your case was among the two cases consolidated into one decision that overturned the doctrine of Chevron deference.
That's right.
Huge. Could you start by outlining to the audience what the doctrine of Chevron deference was?
Sure. So Chevron deference came from a 1984 Supreme Court decision. And what it said is that if a statute is either ambiguous or if there's a gap in the statute so that the meaning isn't entirely clear, that if an administrative agency comes in and it makes an interpretation of that ambiguity or gap that the court considers reasonable, then the court has to defer to that agency's interpretation of the statute. So essentially you're taking the independent judgment away from the judiciary and you're instead telling those Article III lifetime appointed judges, just listen to whatever the administrative agency says.
Right. Well, I can imagine, just hearing that definition, the way I imagine it would work in like a nice, in a benevolent society where you take it sort of at face value that it was, totally intended for a good purpose, is like if a statute says water has to not have a dangerous amount of benzene in it, drinking water. And then the relevant agency has to determine, okay, what's the level of benzene that would be allowed in drinking water to not make it contaminated, parts per trillion or something like that, right? So that's like the law, and then the agency interprets that law in actually executing. So that's the positive, I guess, side of the doctrine of Chevron deference.
Yeah.
What were some of the negatives that came out over the past several decades?
Well, let me stick with your example for a second. So imagine that Congress has specified that about benzene and the agency looks at that, but then the agency says, you know what, we need to look at some other substances as well. Let's take a look at, pick your favorite, let's say lead. We need to look at the level of lead as well. Congress didn't say that, but that's just because it's a silence in the statute. It's a gap in the statute. Well, it could be that Congress had very good reason why they didn't want that particular thing regulated. Maybe they didn't want that agency to do it. Maybe they didn't view it as enough of a problem yet to command sufficient resources, whatever the case may be. But if the agency then takes it upon themselves, you have the growth of the regulatory state that we have seen. When you ask about some examples, so the particular example in the Relentless case and the Loper-Bright case, which was the companion case, is the same underlying statutory issue. It's kind of a fun one. It's from the Magnuson-Stevens Act, which is not one that maybe people have heard about a lot, but it governs fisheries in the Atlantic and Pacific and in the Gulf of America there as well. So the question was, the law says that you can have these government-appointed agents on your boat, and you have to provide them a berth on the boat, and you have to feed them and take care of their safety and so forth. And they're there to make sure that you're obeying the law, to look at the bycatch, things that you're catching that you didn't intend to catch, checking on fish stocks. They have these different jobs. Okay, fine. There may be a role for the government to try to keep the fisheries sustainable. But then the OSHA Fisheries, which was the regulatory agency in question here, they said, you know what, Congress has not given us enough money to do what we want to do with these agents. And we don't have enough to hire as many of them as we want to hire. So what we're going to do is we're going to charge the boat captains or charge the boat companies for the cost of the salaries of these onboard monitors, is what they're called. And the boat company said, wait. Congress never said that.
How much were these salaries?
It was costing about $700 a day to put one of these people on your boat, which oftentimes was more than the profits that were being made from the herring catch.
It's $700 per day, just every day?
Every
or
day.
Or is it like a period of time for inspection?
Well, every day the one was on the boat. And there's some complexities in the underlying fact pattern. So some boats would go out for a day or two, and if you were only out for a little while, you were allowed to have your dockside inspection. But our boats were larger. They could go out to sea for 10, 12, 14 days. They could freeze their catch on the ship, and so they had to have an onboard monitor
at all times.
Not at all times, but it worked out to about half the time that.
At half the time, the government forces you to pay an employee of the government $700 to be on your boat.
Yes, that was what was happening.
And Congress never
authorized that. Congress never said that could happen, but it was a gap or ambiguity in the statute, or at least that's what OSHA Fisheries said.
Right.
We pointed out, look, it's not actually a gap because Congress did say there are 3 circumstances in which you could charge the boats for the onboard monitors. Mm-hmm. One, if it's in the North Pacific. Well, these guys weren't in the North Pacific. They were in the North Atlantic. And the Atlantic and the Pacific are different oceans, as I'm sure everyone except OSHA Fisheries recognizes. Secondly, if it's a foreign vessel. Well, that makes sense. If you have foreign vessels coming into American waters to fish, we would want there to be an onboard monitor, make sure they're not stealing all the fish, and we're going to make them pay for it. Fine. Mm-hmm. And then the third condition was one that didn't apply to any of these boats, and no one said that it did. It wasn't really in controversy. And so when Congress has specified 3 conditions when you can fund the boats, that's not really a gap in the statute. It means that every normal person who reads that says, well, then you can't charge them in any of these other circumstances.
Right.
But that's not what OSHA Fisheries decided, and that's how the case got all the way to the Supreme Court.
Wow, I feel like that particular agency pushed the limit, thinking is it because this doctrine of Chevron deference, are there like many such cases where it's like well beyond what the statute says, or was this particular agency really going like a step beyond what all the agencies were doing?
Well, I'm sure they didn't make any friends at the other agencies by getting Chevron deference overturned. But I don't think it was that different than what we've seen in other agencies. Agencies, really? Because they've had 40 years of the almost reflexive deference from the federal courts, they've gotten used to pushing the limits, right, as you say. And so they do it more and more and more every year, and that's why it was so important for the Supreme Court to step in and say, no. It's the job of the courts, and the Constitution says it's the job of the courts to decide this question.
All right, just to pause here for a super quick moment. Listen, it's obvious that the financial system is not looking too great. After being pumped up with trillions of virtually free government dollars for many, many years now, well, the stock bubble might actually burst in the near future. And in that process, unfortunately, it could take away the nest egg of anyone who happens to be exposed to it. And so consider taking this opportunity to diversify into something which is beyond the grasp of Washington, D.C. and Wall Street, physical gold and silver. And the best company to use, in my opinion, is the sponsor of today's episode, American Hartford Gold, who, I should mention, is also my own personal gold and silver bullion dealer. And besides myself, they have thousands of 5-star reviews from other Americans, and they also have an A+ rating with the Better Business Bureau. And working with them is rather simple. They have a huge selection of coins, bars, and rounds to choose from. They have super friendly staff who you can call, and they can set up either gold delivery directly to your doorstep, or they can even set you up in a gold IRA. And then lastly, best of all, if you tell them the Roman sent you, they will throw in a free gold coin with your first qualifying purchase. So give them a call. The number is 866-242-2352. That's 866-242-2352. Or you can simply text Roman to 65532. I'll also throw a link to their webpage. It'll be down there in the description box below.
And in particular, Congress had decided in 1946 in a law called the Administrative Procedure Act to give that responsibility to the courts, that when it comes to a federal regulation, that the job of determining what the law is belongs to the courts, not the agencies.
Okay, last question. Now that the case was successful, right?
Yes.
The Supreme Court overturned this doctrine. What does that mean for common Americans throughout the whole country? Like, what specifically, can they expect to be different in their everyday lives?
Well, I think one of the things it means is that agencies are going to they're not going to be as apt to overreach. They're not going to try to push the limits of the law, because they recognize that if they try to do that they're going to get slapped down by a federal court. I think it also means when they write the regulations in the first place, they're going to try to write regulations that actually implement statutes that Congress passed, and not just the wishes of the agency that they think might fill a gap or an ambiguity in the statute.
Right.
So it really, I think, puts the onus back on Congress to be the one legislating, and if it's going to be charging people for something or taking away some liberty that people have, Congress needs to vote on that. They can be accountable, and it's not the faceless bureaucrats making those decisions and getting away with it that way.
Well, listen, that victory was probably one of the biggest blows to the administrative state. right? I mean, literally, you took
Yes.
their ability to create laws, essentially,
That's right.
out of their hands.
That's right.
Mark, thank you so much.
Yeah, absolutely.
as
It
an
was
American.
a pleasure. Believe me.
Thank you for the interview, and thank you as an American for what you did.
Absolutely. NCLAlegal.org.